I'm sorry.
Hold on.
Good morning and welcome to our presentation today. Our webinar discussion will be around the Corrections Officer Plan, a benefit overview. We welcome everybody who's signed up online through the webinar and those who made it into the office today for this presentation. We hope your questions will be answered today, and as we go through our discussion, we've divided our presentation up today into about 3 or 4 different sections. We will have a time for questions in each of the sections, so feel free to type your questions in if you're at a remote location through the webinar, and we'll have those posted at the given point in time as we go through the presentation today. So what I'd like to do is start off by giving you some objectives that we have for the discussion today. We're going to look at all of our recent legislation changes affecting the CORP in detail. We're going to explain and give examples of who are the new members within the plan. We're going to distinguish between our service, our credited service, and our compensation. We're going to discuss specific changes and give examples to the calculation. We're going to compare the former law and the new law, and we're referring to these as groups in Tier 1 and Tier 2 members. And we're going to provide an overview of the benefits available, eligibility parameters, and corresponding calculations. And as I'd mentioned, we're going to answer all questions that will be set forth today, and we'll take 3 different parts of the presentation, take a break, and take questions as we go through. So we'll also provide some additional resources for you, the local board, to learn about and grow and develop your expertise in this area. So to start our presentation today, we'd like to start off with what actually changed with Senate Bill 1609. Now, this has been an interesting question because there are some changes in the Corrections Officer Plan that, as local board secretaries or local board members, you do need to know about. We want to look at the laws that actually were affected by this. And for members in the Corrections Officer Plan, the statutes have been affected through Senate Bill 1609 that was enacted in July of 2011. In 38881, there was definitions, there was membership, normal retirement, conditions and pensions, ordinary disabilities, and for all of that, employer and member contributions, retired members, return to work, benefit increases, and deferred annuities. And so what we'd like to do is take each of these sections in Section 38 and go over these in Title 38, Chapter 5, Article 6, and go through each of these in detail with you today. So if we're ready, let's go ahead and get started and discuss the question that always comes up: who is a new member? Now, this is because of Senate Bill 1609, we have to distinguish now a new member as an employee who came into the system before January 1st, 2012, and perhaps somebody who was employed with a Corrections Officer Plan after January 1st, 2012. If we look at this in detail, an employee who becomes a member in the system is an individual whose service and corrections officer employer prior to January 12th and continues with his or her employment with you as an employee, as an employer. An individual who has service with Corrections Officer Plan also is prior to that, begins a new employment with a different Correction Officer Plan and has her time transferred in accordance with the law. We also refer to this category as Tier 1 members. Now, as we think about this, this is somebody who's already been working with you or transferred in prior to this date. Now, what happens if you've hired somebody in the last 45 days? And this would be somebody who would be an employee that was hired after January 1st. He would be considered a Tier 2 member. And this is a person who has no existing credited service. He begins the new employment on or after January 1st, 2012. This is an individual who maybe had redeemed all prior service, refunded his money, and started as a new employee. Now, as we want to go through our discussion today, we want to make sure you understand that's the difference between a Tier 1 and a Tier 2 member. So let's take a few examples of who this individual might be. Let's take, first of all, John Smith just graduated from the ABC Academy. He has no experience with any corrections officer employer. On January 1st, 2012, he was hired or after and worked for XYZ County as a corrections officer. Now, in your opinion, based off the discussion we just had so far, would he be a Tier 1 or a Tier 2 member? That's right. He'd be a Tier 2 member, a new member with you as an employer. How about Joe Black? Was a corrections officer in ABC County for 8 years. He still had all of his previous time and money on account. On February 3rd, 2012, he was hired to work for XYZ County as a corrections officer. In other words, he had money on account. Would he be considered a Tier 1 or Tier 2 member? Oh, good answer from the group here today. He's not a new member. He's a Tier 1 member continuing with his credited service on account. That's the key to that particular question and discussion. Let's take, for example, Jane Doe. Was a member of the corrections officer plan for ABC County for 15 years. She worked a long time but needed to withdraw her money for personal reasons. There was no contributions on account on December 31st, 2011. But just recently, a few weeks ago, she hired back on March 10th of 2012. She was hired to work for XYZ County as a corrections officer. Now, is this individual a Tier 1 or Tier 2 member? I see everybody holding up their fingers. That's right. It's a Tier 2 member. It's actually a new member within our system. So hopefully this discussion has brought forth some light to you of who should be considered on a Tier 1 or Tier 2, considered as a new member or a member who is already making contribution in the plan. In summary, if the employee was a member of CORP prior to January 1st, 2012, and his or her contributions to the system remain in his or her account as of January 1st, 2012, that employee is not considered a new member, which we're calling a two-tier plan. So let's go ahead and take just a minute and open it up for questions for those that are on the webinar so far. Do we have any questions from those? What you'd simply do is type your question below on the question dialog box and go to the webinar application, hit the send, and that will send it to the presenter, who will then type the question and we'll put it up here on the screen. Let's go ahead and take questions from those that are here today. Do we have any questions about this today so far? Looking around the room? No questions. How about from those who are on the webinar? Okay, we must have done an excellent job in our discussion so far. Let's go ahead and move on. So you can see that if you are in the webinar, we will ask for questions as we go through the presentation at certain points, and then you'll just send your questions in and we'll discuss them so everybody in the state will be able to hear the answers. So let's go ahead and move forward now and continue our discussion. We want to take a little discussion and take a little time now and discuss what service is, credited service, and also compensation or salary for an employee. When we're done with this discussion, you should be able to distinguish in your mind what's the difference, of course, between service and credited service. Now, as we break this down in 38881.43, it's service is all the last period of a continuous employment with an employee with an employer prior to the employee's retirement date. This includes the industrial leave without contributions, leave without pay, family and medical leave act. But if you take a look at the actual definition of what credited service, you'd want to look at AS 38881.11, and that's contributions that are made for the industrial leave and normal pay cycle. Any redeemed prior service. So remember, leave without pay only affects credited service when no contributions are submitted for a pay period. So if you want to distinguish and always want to think in your mind, if a person has service, but maybe he didn't work for a period of time and no contributions received, then that would reduce his service time to just what we would consider as credited service in the system. So let's take a minute and look at what compensation is. Covered compensation is usually in the corrections officer plan, his base salary. Maybe there's some shift differential pay on a regular payroll basis. Maybe there's a little holiday pay or unused sick or vacation leave also. But you have to remember the law is very specific that there's no real overtime in that situation, but contributions should not be made on fringe benefits or lump sum payouts. So I think if you have any questions about this, you need to make sure you've talked to our active members group and make sure that you're only contributing on usually his base salary at this point in time. So let's go ahead and now we know what covered compensation or salary means. Let's look at specific changes to the retirement criteria and the calculations. What we've done is put together some examples for you so you'll be able to see what will be happening as you're going through the calculations for a Tier 1 and a Tier 2 member. Let's take an example for a normal retirement on a Tier 1 member who became an employee and been contributing for many years. He actually would be able to retire with 20 years of service, 25 years if he were a dispatcher, or an individual who had worked 10 years of service with 62 years, or the sum of the member's age and years of credited service equals 80. Now that's just a simple definition of what a normal retirement would be and the criteria for that individual to be able to receive a pension. What we'd like to do is take you through now the calculation. If somebody had worked 20 years and it's 50% of his average monthly salary based on 3 consecutive years of service of the last 10 that he worked. You'd also add, if he worked beyond that, 2% for any years beyond 20 years up to the 22.9 years. At 25 years of credited service, the multiplier, as we understand it, is increased to 2.5 above the 2.0. For a person who has less than 20 years of credited service, the calculation of the benefit is multiplied, and the member's average monthly salary, 2.5 years of the member's credited service. And remember, there is a maximum benefit of 80% of the average monthly salary based off the high 3 consecutive years. In other words, you cannot get more than 80% of his high 3 years. So let's take an example and break this down. For example, John White began working for ABC County as a correction officer in 1992. He worked most of his life, and at age 52, he had completed his 20 years of full service of credited service. He is eligible as a Tier 1 member, and you're probably retiring many of these individuals right now. The employee would apply for a normal retirement. His average monthly salary is $4,000, and he's making application to be able to retire. To calculate his estimated pension benefit, you would take his average monthly salary, which we've established, times 50% would equal his monthly benefit. So if he had $4,000 of salary times 50%, it would be half of that, $2,000 the rest of his life. Now, is there any questions about that, how that's calculated? If not, we'll go ahead and proceed to our next example. Let's take an example for a normal retirement, a Tier 2 individual, because now the criteria changes because not 20 years, but they have to work 25 years in the corrections officer plan. This is somebody who became a member, as we said, a new member on a Tier 2 plan. This individual will have to work 25 years of service and age 52 and a half. This is the new criteria within the law. Or the 10 years of service at age 62. Now let's take an example because this is a little bit different than the one we just looked at for those who are currently working prior to January 1st, 2012. The calculation is based off of a 25 years of credited service. It's 62.5% of the average monthly salary based off the highest consecutive 5 years, not 3 years, but 5 years in the last 10 years. You'd add 2.5%, as we'd mentioned before, beyond the 25 years of credited service. For less than 25, it's the same multiplier factor. And again, it maxes out at 80% of the average monthly salary based off of the 5-year consecutive in the last 10 years. So that's a big thing to make note of, that it's not a 3-year average, but it's a 5-year average going forward on a Tier 2 member, and he has to work 25 years and reach the age 52 and a half. Now let's take an example of this. Joe Johnson began working for XYZ County as a corrections officer in 2012, this year. Years later, at age 50, he actually was able to complete 25 full years of credited service, and he's now eligible as a Tier 2 employee for a normal retirement. Same parameters, his average salary is $4,000. Boy, salaries didn't go up in the last few years, did they? To calculate his estimated monthly benefit, you would take his average monthly salary times 62.5, which would equal his monthly benefit. Now, in this case, it's a higher multiplier. Even though his average salary is $4,000, it's multiplied by 0.625 or 62.5%, and that would net him $2,500 for a pension benefit for the rest of his life. So you can see that even though the person may be working a little longer, his benefit will be a little bit higher if you can project out the full 25 years of service. So although he met his service requirement, though, as a caveat, he will not begin receiving his pension until he reaches age 52.5 years old. This is a new caveat of the law that you need to understand. Even though he reached the full 25 years, he has to wait till the age requirement as well of 52.5. Let's take another example so you can see the comparison between each of these calculations. Perhaps an individual worked 25 years of credited service, 62.5 of his average monthly salary, but for less than the 25 years of credited service, now we're going to reduce his pension just a little bit. Let's take an example of how that would actually look. Jill Brown began working for XYZ County as a corrections officer. Years later, at age 53, she'd completed the full 25 years of service. She had less than 25 years of credited service, though, because she had a little bit of leave without pay or a period of time where she was not working. No contributions were made. That would equal about, 13 pay periods or about 0.5 years. She's still eligible as a Tier 2 employee for a normal retirement, less the deduction for each year of service, less than the 25 years of credited service. Her average monthly salary is $3,000 a month. How do you think this would be calculated? Well, let's take a look at it. To calculate her pension, you take the average monthly salary as step 1 times the 0.25 of $75. Step 1 times the credited service is the actual monthly benefit. 75 times 24.5, which is 1837. But we want to make sure we understand that the maximum benefit does not exceed the 25 years. Oops, hold on just a sec. So let's go back to this example. Does that make sense how the person would still receive a benefit, but it would be reduced? Let's take another example of somebody who worked 25 years or more accredited service, but perhaps exceeded the maximum benefit of 80% as the calculation was done. So let's take this example and walk through the steps. Jerry Smith began working for XYZ County in 2012. Years later, at age 60, perhaps this individual worked 37 full years of credited service. He's eligible as a Tier 2 employee, plus he'll get additional service beyond the 25 years. His average monthly salary is $4,000. To calculate that, you take the $4,000 times 0.625 of $2,500, because the full benefit times 2.5% because he worked beyond those years is $62.50. So you'd add that together and you'd have an additional per year dollar times the number of years equals the annual additional amount of $750. So the full monthly benefit plus the annual additional benefit, his actual benefit, if you calculate it out, would be adding $2,500 plus the $750 is $30,250. Now, do you think he'll receive this full benefit? Based off the law, he would only be able to receive 80% of the maximum benefit of $3,200. So per the statute, the member will receive the maximum that would be allotted to him. So we've tried to go through and give you various examples, different discussions of different calculations, so you can see somebody who would maybe have more than 25 years of credited service. What we'd like to do is now open the discussion to those who are on the webinar. If you could just type in your dialog box and press send, you'll see the questions will be presented to the presenter, and we'll move forward at this point. Do we have any questions from anybody here at our location so far today? How about any questions from the webinar group? Wow, we must be really, really good at explaining this today. All right, what I'd like to do then is take just a minute and go into some more detail of what actually happened with the changes with the law and make some comparisons. Now, we'll still have to take questions at the end, so if you have something come up, jot it down, and we'll be sure to answer those questions for you. Let's take a few minutes and talk about the former law versus the new law, Tier 1 and Tier 2 members. This is a good discussion in terms of what can we actually glean from what the law has been presented and how we can break it down. We need to know what actually has been changed because of Senate Bill 1609. The normal retirement criteria, we're going to go through the compensation of the retirement calculation. We'll go through deferred annuity, reverse deferred retirement option plan. That actually didn't have many changes. Disability, survivors, benefit increases, employee contribution rates have changed, return to work, alternate contribution rates, termination of members and refunds, transfers, and service purchases. So if you look at that long list, you need to know exactly what happened with the law and how that compares to what happened prior to the law being passed this last year. Let's take each one individually now. A normal retirement, as we discussed earlier, would be a 20 years of service, or 25 for dispatchers, 10 years of credit service, 10 years of service and age 62, and the sum of the member's age plus the credit service equals 20. We just got through going through examples of how that would work out. If you look to the right of that, you'll be able to see that the normal retirement for the new law, Tier 2 members, would be 25 years of service plus the age of, and the age 52 and a half, 10 years of service and age 62. But at termination, the member must meet both the service requirement and not only the age requirement. Once they have the age requirement is met, the member is eligible to apply for the pension, just as the examples we gave you before. So hopefully that clarifies that in your mind of the difference between the two laws and how Senate Bill 1609 affects the normal retirement. Now, we gave you a few examples a minute ago about how the compensation is used for the monthly calculation. Let's just review it, how it is currently with those who have been contributing prior to January 1st, 2012. The average monthly salary is based off the 3 consecutive years in the last 10. It's 20 years of credited service based off the high 3. There's a 2% multiplier. There's at age 25, the multiplier increases to 2.5%. For less than 20 years, the calculation is multiplied by the following together, and there's a reduction for based off the credited service. And again, as we explained in the examples, the maximum benefit is 80% of the average monthly salary. Now, what do you see as a large difference between, and point number 2 on the slides, for compensation under Tier 2 member? As you can see, the biggest thing is the average monthly salary is for 5 consecutive years out of the last 10, not 3 years. 25 years of credited service off the high 3 years. There's still the 2.5% multiplier. There's still a reduction for less than a certain number of years, and there's still a maximum benefit of 80%. So it's just interesting to note that a person would need to have an average monthly salary of 5 years and have the 25 years of credit service and age 52. That's the thing we want you to glean from this particular slide. Okay, let's take a minute now and take another example of what else was affected, the deferred annuity. Perhaps a member terminated employment for reasons other than retirement or disability with 10 years of credited service. He can apply for the benefit at age 62. The benefit would then be granted at age 62. The legislation clarified that it is not a pension, so the member is not entitled to survivor benefits or benefit increases or insurance subsidy at that point. but the benefit is based on contributions. Now, on a Tier 2 member, deferred annuity is not available to any new hires, but it does state in 38.911B, it states, such a person who attains normal retirement age for an eligible retirement and retirement benefit, if the member terminates employment with an employer before the age, he would still have to obtain the service credits and the normal retirement age. However, the member cannot receive his benefit till age 52 and a half. And those are the examples we just gave you a few minutes ago. So if you look at deferred annuity, there is a bit of a change there. It's not available to new hire after under the Tier 2 members. Now let's take a few minutes and discuss this, because a reverse drop, that's been a program that's been in effect for a few years now. Normally that's a 24 years of credited service or 25 years for dispatcher. It's not awarded for an accidental, ordinary, or total or permanent disability pension. The employee may participate for no more than 60 consecutive months. The employee and employer contributions that are deposited during the reverse drop period are not eligible for a refund, and a member in a reverse drop account shall be credited with the following amounts. Now you can see that from this, the amount is credited, the drop date is set, and everything is moved back to the date in which the person retires. That amount is then given to the person through an accrued monthly, and then that represents the interest rate equal to the yield of a 5-year Treasury note. So the main thing you need to glean from this information is the person works, we'll just say 37 years, reverses drop to 32 years, and then a pension would be paid plus some interest involved. That's really essentially what the slide represents here. And he'd receive an 80% maximum of his pension. But also in the law, it does say that this program will terminate, or sunset clause, in June 30th, 2016. So there aren't too many that would qualify for the reverse drop, but we want to make sure you understand what the law does say about that. Now, if you're a Tier 2 member, it's still the same as a Tier 1, but remember, this is a caveat again, that the normal retirement is 25 years of service and age 52 and a half. So you'd have to meet that criteria and work beyond that to reverse back to the 25 years. So just be aware of that as a person in 25 years getting ready for a reverse drop. But by then, according to the law, it may be a sunset and it would be a moot point. But we want to just make sure we explain the difference between these two and a reverse drop. Let's take a minute now and see what's been affected by the disability retirement. Accidental disability is job-related, mental or physical, totally and permanent, prevents the employee from performing a reasonable range of duties, resulting from a physical contact with perhaps an inmate or prisoner, parole, or persons who are on probation. So you can actually see that there is something that would happen if a person was working at the job and had a job-related accident. A person could apply for a accidental disability. An ordinary disability also would be granted if a person had a physical condition that would totally and permanently prevent him from performing his reasonable range of duties, or a mental condition that totally prevents him from working and engaging in any substantial gainful activity. So that would be another type of disability a person could apply for. The third type of disability that is available under the current law, or we'll call it the former law, Tier 1 members, is a total and permanent. And this again is a job-related physical or mental condition that is not an accidental disability, and it prevents him from fully engaging in a full gainful employment. So if you were any member of the working force in the corrections officer plan and something did happen to you, you would be able to have some type of coverage under one of these types of disabilities. Now, that also applies to anybody who's a Tier 2 member who recently got hired. It's the same benefit structure for those who on the Tier 1 members. So we just wanted to present this information to you because there are 3 types of disabilities. They all are a little bit different, and the local board would treat them as such. Let's take a minute and go through the discussion of how these are actually calculated. An accidental disability is 50% of the member's average monthly salary, or the amount computed by the member's average salary and the member's actual years of credit service, whichever is higher. And again, anybody could apply for this if they are currently working under the Tier 1 members. Ordinary disability is the same, very similar calculation, but just a little different because the member's credited service is divided by 20 years or 25 years if it was a dispatcher, multiplied by the member's normal retirement benefit. And then the total and permanent is 50% of the member's average monthly salary, computed using the member's average monthly salary and the member's actual years of credited service, whichever is higher. So you can see any member could apply for any one of these particular retirement plans or retirement benefits if they so needed them. But the eligibility on each of these is based on an independent medical examination that would have to be performed by the member or by the board, by the local board would direct that. They would may be required to have the periodic medical evaluations until a member reaches age 62, and the disability benefit may terminate if the local board finds the retiree no longer meets the requirements for the disability. So it is a process that you would go through to actually make application for a disability, and anybody could apply for that. The same holds true for the Tier 2 members because it's the same procedure for an accidental. The only difference for an ordinary, the member must have credit service divided by 25 years instead of 20 years because it's a new plan as far as the benefit calculation, and the total and permanent is the same as we just discussed. But remember, the average monthly salary is calculated on the 5 years of consecutive years, not the 3 years, as we previously mentioned. So these same as the disability retirement eligibility for same as the Tier 1 members. So we wanted to just go through this discussion today to make sure there's no question in your mind that if something happened to the member, he would be able to qualify for a particular type of disability. What I'd like to do now is take just a minute and go through point number 6, and this would be for the survivor benefits. For a Tier 1 member, the spouse of a retired member, married or deceased, would have to have at least 2 consecutive years from the member's date of death. The benefit would be 80% of the member's monthly benefit based off of a 3-year calculation. Now, that's if the person is retired and a survivor of a spouse would get a benefit. How about if the spouse of a deceased active member and there's no marriage at the time of the requirement, but the benefit is 40% of the member's average monthly salary? Now, what happens if you had a spouse of a member that dies as a result of injuries received in the job? Then the benefit would be considered as 100% of the member's average monthly salary. So if we take a look at that, you'd be able to see in your mind that there is some type of benefit for all spouses who were working or retired. There'd be some benefit paid. Now, if you look at the Tier 2 side for the survivor benefits, it's the same as the Tier 1, but remember the benefit is calculated off the highest 3-year salary, not the highest, it's based off the highest 5-year salary, not the highest 3-year salary. Now let's move down to point number 7. There's a benefit increases eligibility. For those individuals who retired members were receiving benefits on or before 7/31 for 2 previous years, or the retirement benefit was 55 on July 1st and receiving benefits prior to that. Now, it's the same as Tier 1 for the benefit eligibility, but there is a caveat to this also, that effective July 1st, 2013, age 55 of a member who's receiving the benefit, or if he's under 55, on July 1st, receiving an accidental disability was received on or before July 31st of the previous 2 years, and the survivor under 55 on July 1st, the survivor of a member killed in the line of duty, also receiving that benefit on or before July 1st, 31st of the previous 2 years. So there's just a little bit of a change on the way our benefit increases or COLA increases will be calculated going forward. So you can see from this discussion, not a lot of changes, but just a few little ones. Now let's take a minute and look at how that benefit increase is determined, because this has been a lot of discussion from our retired members so far. Right now, there's no more dollars or monies left in the excess investment earning account that will be going into the COLA reserve. In the past, we've been able to fund COLAs up to 4% of a person's pension, but that's no longer going forward. Effective July 1st, 2013, right now, for any excess investment earnings to be moved into the COLA accounts, it needs to earn more than 10.5% in the prior fiscal year in order for COLA to be issued. But our funding ratio within our system has to be between 60 to 64% for a 2% increase, 65 to 69 for a 2.5% increase, or 70 to 74 for a 3% increase, or 75 to 79% for 3.5% increase, or 80% funding ratio for the entire plan to receive a 4% increase. So there are some limitations to actually funding this particular COLA account. Now, if the earnings are 10.5% are insufficient to the fund's percentage increase as set forth above, then the increase will be limited to what can be funded by the available earnings. So you can see that at the time of the COLA increases are kind of in the past at this point, and I wouldn't bank on them or count on them for the next few years until things change around on the funding ratio and our investment earnings are above the 10.5%. So as you can see that the benefit increase determination is the same as the Tier 1 members under Tier 2 member. But these are changes enacted by Senate Bill 1609, and they affect all current Tier 1 members going forward. And year to date, our investment return is not in the positive, so I don't think we'll be making this year a ridiculous amount of a 10.5% increase, just for your information. Now, what happened to the employee contribution rate? We said we were going to go through 13 points. We'd like to go through point number 8 now with you. How about if an employee's contribution rate has been set forth on 7/1/2011 and carried forward is set at 8.41%? Now, that's what the employee will be paying going forward. Dispatchers are a little bit different because of their funding ratio. The dispatchers will be at 7.96%. Now, going forward, it'll be a 50-50 split between the employee and the employer, whichever is lower, with the minimum employee contribution rate set at 7.65 and 6% for the employers. The dispatcher rate will be 0.45% less than the other CORP members until the plan is 100% funded. So you can see that the employee rates are set by law and will continue, but the employer rates could fluctuate based off of the actuarial information that's been presented each year. So that's the same as the Tier 1 for contribution rates for the employees. Now, we've had a lot of discussion on point number 9, and we want to spend a few minutes discussing this. If you had a return to work rules, we need to go over this in detail with you today. This may be an employee who cannot return into a CORP designated position for 12 months with any CORP employer. Now, this is somebody who's retired already and coming back to work. That's what return to work means. An employee cannot return into a CORP designated position for 12 months with any CORP employer. The retirees reemployed in a CORP covered position do not make contribution and do not accrue any service. So there's not adding any more service or credited service to that particular individual. Now, the employer, in addition to that, also needs to make an alternate contribution rate on behalf of CORP retirees into the CORP covered position based off the retired member's new salary. Now, we'd refer you to 38,891.01 for full details of how this would work. Now, this is the same as a Tier 2, but we want to make sure you understand going forward, this is another change to Senate Bill 1609 that affected all Tier 1 and Tier 2 members. Now, if you're not familiar with this, hopefully we'll have more discussion on this as we get into the question and answer period. But those are the major points that a local board needs to be aware of as the employer if you are going to rehire or have somebody come back to work after sitting out for 12 months or 1 year. Now, if that employee does come back a retired member then there is an alternate contribution rate. We're referring to that as an ACR that does need to be paid on behalf of that employee for coming back and taking a CORP covered position. The employer must continue to make an alternate contribution on behalf of CORP retiree in any covered position on a retired member's new salary. Now, how do we determine that? That ACR should be set at least 6% and will be equal to the portion of the total required contribution applied to the amortized of the unfunded actuarial liability for the fiscal year based off the actuarial's calculation for a total required contribution for the preceding fiscal year. So what does that mean? It means to you there is going to be an additional rate that will be applied to anybody going forward, and it's set at 6%. The ACR will be applied to the compensation, gross salary, or contract fee of a retired member as applicable. Now, these contributions made by the employer will be allocated to the fund are irrevocable. In other words, you've got a seasoned, experienced individual who's worked for so many years and said, okay, I've taken a year off. Now an alternate contribution needs to be made. The employer must submit all of this information to our office based off the way the law is written today. Now, that same is true as a Tier 2 member as well. So be thinking about that as you do think about hiring back somebody who's already retired. That's what an alternate contribution rate is somebody who's retired, set out for a year, and come back to a designated position within your organization, a covered position, and you do need to make contributions on that individual. Let's take a few minutes and look at a comparison of the old law and new law for termination of memberships and refunds. This is kind of an interesting point because when a person leaves, he's entitled to receive a benefit, I should say a refund amount. If a person has less than 5 years, it's just the members' accumulated contributions within the plan. But if it's more than 5 years, you can see the percentage rate goes up to 25, 40%, 55, 70, 85%, or 10 or 100%, and that would be taken from the employer accounts. Now, as this has been designed, if it's a person who has 10 or years more service, if the money is left on account for more than 30 days, an additional interest rate may be applied. So that's what the old former, we'll call it the former law or Tier 1 members benefit amounts as it stands today. But it's a little bit different now going forward, because if you terminate under a Tier 2 member, in other words, the person starts in February and terminates 6 months later, it's a whole new program for that group of individuals. Because on termination of his employment for any reason other than death or retirement, with 25 days after the filing is completion with the board, a member is entitled to receive a lump sum payment equal to the member's contribution rate plus a little bit of interest. Now, the Board of Trustees will set that, and less any payments made to the person for that individual. So you can see on the Tier 1 members, a person could work for 6 years and get a little bit of money back, plus 40% if you work 6 years. But in this situation, the current interest rate is set by the board at a flat amount of 3%. So I want to make sure you're aware of that, because I know a lot of times in corrections officers work, a person may work for 4 or 5 years or 7 years and refund their money and then maybe come back to work later because they need the money. But the interest rate will not be as lucrative as it was in the past. So you're aware of that, and you can explain that to the members. What about a transfer? This is a member who terminates employment, who accepts a position within 2 years, perhaps with the same or another employer, may be able to transfer his credited service, put the money on account, and set that up however that person may need to have it transferred into the new agency. The new employer's account shall be credited with the member's accumulated contribution and equal to the actual present value, so they would be transferring year for year in another CORP position. Transfers did not get affected by Senate Bill 1609. It's the same for a Tier 1 or a Tier 2 member. So you do have some flexibility and portability from moving from one employer to another under the transfer laws. Let's take a look at point number 13. This is interesting that now that a member must have 10 years of credited service in order to redeem any qualified prior service or military time. The member is limited to purchase 60 months of prior public service or 60 months for any military service. And it's the same for Tier 1 and Tier 2 members going forward. But we just wanted to point that out, that a person may be able to purchase some service time if he has 10 years of credited service. So we've gone through all 13 points now, and hopefully this has been a good discussion for you. What we'd like to do now is open this to any discussion from anybody who's here in attendance or who's remotely signed in through the webinar. Let's take a few minutes now and type in your questions or concerns you might have of things you've thought about as we've moved through this presentation. We're not done yet. We still have some more things to discuss. Any questions from anybody here in the office today? None said. Let's move on to those who are in the webinar. Any questions? Boy, we are doing a great job today. We had a lot of discussion last week in questions. All right. If there's no questions, we'll go ahead and move forward. We do want to continue with our presentation now. And talk a little bit about the insurance benefits that are available to our corrections officer members as they get ready for retirement. This is kind of a interesting scenario that retiree health insurance subsidy is available, but each Arizona retirement person may have a certain premium amount or benefit that's going to be used, and there'll be a subsidy applied to that for the retiree. The subsidy amount is really applied or based off the insurance plan or type, whether it's family or single coverage, and Medicare eligibility. This amount is applied to the member's total cost for dental or medical, and is taken out of their pension or billed by the insurance administrator. So we want to make sure everyone's aware that there is insurance available to any corrections officer member who does retire, and there is a bit of a subsidy to supplement that as well. Now, who is eligible? The Board of Trustees shall pay this premium to each retired or survivor member as they've been designated by the law. So I would say that's pretty much everybody that retires ought to be able to get some type of coverage. Now, where does this premium coverage come from, and who qualifies for this payment? The system defines it as a health insurance or medical dental coverage. The coverage is with the current employer, could be extended through a COBRA coverage or retiree health insurance offered by an employer. Also, the retiree health insurance coverage offered by CORP or through ASRS, Arizona State Retirement System as well. So additional information you may need to be aware of is when this member is eligible for retirement benefit, he could actually have two different retirement systems and may be eligible for public safety retirement or CORP retirement, and two subsidies would be applied. The Medicare eligibility is defined as a person who's 65 or older, but in some cases, the disability can obtain Medicare earlier. So let's see what those subsidy premium amounts, or how much the subsidy would be paid towards a premium. It'd be $150 for a member only, not Medicare, for single coverage, $100 for Medicare member only, Medicare eligible. It jumps for family coverage to $260 for a member and dependent, but no one is on Medicare. $215 for a member and dependent, at least one is on Medicare for a family coverage, or $170 for a member, but one's on dependent or on Medicare eligible on family coverage. So there is a single versus a family coverage premium that would be applied towards any particular premium for somebody who's retired for an insurance. And this is, again, an added benefit for you. Now, if you have any questions about the Corrections Officer's Retirement Plan health insurance resources, we wanted to make sure you had available. Annette Jorgensen is available, or Stacy Alcott from our insurance department. And their fax number is also listed here as well. So with that said, we wanted to make sure you understood that is another benefit or available to our retired members. Any questions about the insurance that's available today? About the subsidy? Okay. Let's take a minute now and request, maybe a person wants to request to remain in a particular plan like CORP or ASRS. We do have available for those individuals a Form C-20 for DOC and juvenile only. A member who has accrued at least 5 years of service with a CORP may temporarily accept a non-designated position and request to remain in CORP now. If you weren't aware of that, we wanted to make sure you were aware of it because this may affect that individual down the line for retirement. This cannot be an indefinite or a permanent move into a non-designated period, but it's just a temporary one, but will be coming back into a CORP position later. The local board that approves this request must notify the member that the board will be reviewing the decision at the end of the year. If the member wants to remain in a non-designated position, he or she should be transferred to ASRS. This is maybe might have a special assignment for a short period of time in a non-designated position, but will come back as a designated CORP covered position at a later date. But the C-20 does give the flexibility for that individual who may want to move in that direction. The other form that we wanted to show is a kind of a, make sure you're aware of, is a Form C-21 for DOC and juvenile. And this form should be completed when an employee who has been in ASRS for 5 or more years is hired or transferred into a new job with the same employer in a covered CORP position and would like to appeal the board to stay in ASRS. Maybe for reasons we don't know about, would like to stay in ASRS and be there for a longer period of time and retire from ASRS, but it does give them that flexibility. But we do need to have either the C-21 form on file with your approval for this to happen. Now, if you have any questions about that or any resources, we do have a complete active member staff. LaDon Toger is the active member supervisor for any transfers or buybacks Tony could help you with, or the discussion we had on any refunds. Connie would be your contact, and Kathy or Allison also help with those particular questions. So we want to make sure you're aware of all the resources available within this department for any of the transfers or any things refunds or these forms C-20 or C-21 that you need clarification on. Feel free to give them a call or email them at the appropriate email addresses. In addition to this, we wanted to make sure you're aware that Robert Ortega or Don Minier, myself, are available to help you continue with your local board training needs. Recently, we put on webinars and downloaded these presentations to the website, and you can see the link there provided. We've gone over some disability retirement paperwork. We had a full hour-long discussion. If you'd like to get into that on the return to work rules, we have the audio and the presentation material on the website. Also, this last month, we hosted an open meeting law discussion. Wonderful discussion in about an hour's time. Went through all the open meeting laws that are available. So those are just some recent training materials we wanted to make sure you're available on our website under local board training. Also, if you'd like to review or any upcoming training events that will be scheduled, you can go to the local board training website and you can see a schedule of those that will be coming out. Our next CORP local board training will be in June, and we'll be taking registration for that. And you'll be able to sign up and come into our office, and we'll have a half-day seminar going over duties and responsibilities in local boards, talking more about the benefits and reviewing maybe actuarial reports. We've just got a lot of discussion topics that we'll be going over in June, so we encourage you to sign up for that as well. Also, we have insights and updates on our bi-monthly local newsletter at PSPRS.com. You can go to local board training and see our current edition, the one we recently mailed out, which we encourage you to sign up for this particular webinar today, but we will continue that as the year goes forward. Other resources that we wanted to just go over with you for a minute that we do have available and let you know that thank you. We appreciate your attendance, first of all, today, and you will receive a certificate of attendance in a PDF file that you can show your employer that you went through this training. The videos we talked about will be on our website for 90 days, and you can locate that. If you have somebody that wasn't able to attend today, maybe a board member that would like to hear this discussion, you can schedule future training events with either Robert or myself, Don Minear. And again, these local board newsletters are always a good help for you. And also, we wanted to make sure that you're aware that on the website that we do have the summary of benefits. You'd simply type in PSPRS.com, corrections officer at the top of the screen. You can look at the summary of benefits and go over most of this material. All of this material, I should say, is on the summary of benefits. If you need a one-page handout to give maybe to a board member to understand what we've been talking about. All right, what we'd like to do now is that concludes our discussion for the day. Is there any particular questions we'd like to take from the group that's here with us in the office? Oh, we just woke them up. Sorry, no. Yes, go ahead. If you could speak up, we'd like to try to get your question on audio, and then we'll maybe repeat it if it doesn't pick it up for those who are not here. Go ahead.
Okay. On one of the slides, you talked about eligibility for membership, and you had talked about redeemed prior service, and to determine whether they were Tier 1 or Tier 2 of the membership. Okay. When you were talking, and it said on the slide, it said redeemed prior service, I thought maybe we were just talking about somebody that had purchased forfeited time, previously forfeited time, and that would, make them a Tier 1 member because they had bought forfeited time. But as we were talking through the rest of the presentation, I thought that maybe military time purchased or other public service may also be considered as credited time. So my question is it any service purchased, whether it was military or other public or previously forfeited, is that considered credited service?
Okay, so to repeat the question so everybody in the webinar can hear, any purchase service used towards credited service. Is that pretty much what the question is?
Is it any purchased?
Okay.
Actually, I'd like to maybe follow up a little bit more on that. Is your question not only is redeemed service considered credited service, but does that also determine what tier they're on? Is that you want to? Okay.
It's twofold because if they had purchased time, does it depend on the type of purchase that it was to help determine whether it's credited or not?
Okay. When it comes to credited service, obviously, all what you've just talked about, redemption of prior service, redemption or purchasing of prior military service, all of that is considered credited service. So that would go towards the individual's calculation when you get ready to calculate their monthly benefit. However, when it comes to determining what tier they're on, the only issue that comes into play and the only change into statutes that allows an individual to still be considered a quote-unquote Tier 1 member because of their time in the system, the only thing that comes into play there is whether or not their prior service maintained on account here. Meaning, I was with the Department of Corrections for 10 years, and I contributed for those 10 years, and then I left the Department of Corrections. I was gone for 2 or 3 years, was hired back with the Department of Juvenile Corrections, and it is now, May of 2012. In order for that individual to be considered an actual member under the Tier 1 benefits, that money and service that was with the Department of Corrections has to maintain in the system in order for it to transfer over to the Department of Juvenile Corrections, and then at that point they would still be considered a Tier 1 member. If that individual had refunded all of that time with the Department of Corrections, took a refund when they terminated with DOC, and then comes back with the Department of Juvenile Corrections, they still have the ability they have the ability to redeem that prior service and go through the service purchase process with our active members group. But per statutes, that person would be considered a Tier 2 member because of the fact that they refunded those dollars. Okay. So I hope, does that kind of clear up the question?
Did, and then you had said it in that first part of it too, that in the calculation for retirement, it is still considered credited
Yes.
Correct.
So I'm good on
Yeah,
both.
it would be considered credited service if they do redeem that prior DOC time. It absolutely would be considered credited service once they get ready to normally retire or whatever occurs for them in the future. But because they refunded, it's considered the individual
over.
themselves would be considered a tier 2 member.
Yeah.
So.
Okay.
Okay, do we have any questions from those who are in the webinar group? We have many who've signed up and participated in this webinar so far. Any questions from the group that around the state of Arizona? I don't see any questions that have popped up on the screen. Any other questions from those that are here? Yes, we have another hand.
My question goes back to figuring out compensation.
Okay.
And overtime is calculated in there with figure compensation, or overtime is not?
Okay, the question is overtime considered salary and compensation, and do you make contributions on that? Is that what the question is? In corrections officer plan, the answer is no. There's no overtime for a corrections officer group to make contributions on his salary in overtime. It's base salary. It's different than public safety. Good question, yes. Okay, any other questions from our group here that's in attendance or those that are out? Yes, we have another hand. Question, please.
Yes, this is something I wasn't at all familiar with. We were talking about the C20, where someone has special assignment.
Yes.
They're obviously getting paid for that.
Mm-hmm.
And working hours, does that money and time count towards their CORP retirement?
Yes, if a person signed the C20 and they're on special assignment on a non-designated position, that's a good question. Does their money that's still being contributed to our plan count towards their service and credit service? And the answer is yes to that question. But they do need to have it on account with us and continue in that service, but they can't go on that special assignment for a long period of time. It has to be a designated shorter period. It can't be like, 5 years or 10 years at this other position.
Do they have to file that form before they start, or can they file it during the time?
Just to follow up, the follow-up question was, when does the individual have to apply for this waiver to maintain either in CORP or to maintain an ASRS? One thing I want to point out is, again, this is only an available opportunity for our DOC group and our DJOC group. There's also some language with the admin office of the courts, our probation officer group. There are some abilities there as well within statutes, but it's exclusively those groups that have that ability. First of all, the individual who is seeking a waiver to maintain in CORP, so that means they're now in a non-designated position, probably an ASRS covered position. If they want to maintain in CORP, when they promote or transfer or whatever it is, moving them into this non-designated position, they must make that request in writing or utilize that C20, make that request in writing within 90 days of that occurring. So they have to put that request to the local board within 90 days of the transfer, promotion, whatever, to ask for a waiver to maintain in CORP. And once the local board reviews that for either DOC or DJOC and they approve that individual, meaning they were in CORP for 5 years before they can even make that request, if they approve that waiver, then again, the employer just continues to contribute while that person's in that non-designated position. Again, understanding that salary that they're contributing against has to meet the statutes, meaning there's no overtime, things of that sort, and they still continue to get the service in CORP. And vice versa, if they want to maintain an ASRS, then they maintain their contribution status with ASRS.
So it's a waiver to continue on working, but you're planning to come back. Very good questions from everybody. If there's no questions from those that are on the webinar, we appreciate your attendance today. Hopefully this has been valuable information to enlighten your minds to be better local board members and local board secretaries. We appreciate those who came in to the office today. Excellent questions, wonderful discussion. Thank you for coming. Until our next seminar, we'll say goodbye for now. Bye-bye now.
That's true. I'm on birthday.